Hello friends, with the great initiative of Company Law Institute of India Private Limited, we have started this series on the income tax cases in which we will try to summarize the whole case in a video of 5 to 6 minutes. The case which we are going to discuss today relates to Lucknow ITAT. The name of the case is SANT AASUDARAM SEWA SAMITI versus Commissioner of Income Tax Exemptions. This case is decided on 29th August 2022 and the matter has been reported in 99 ITR Tribunal at page number 531. The result of this case is very unique and the facts are very general. In this particular case, the assessee applied for Section 12A exemption. The assessee was new, hence no activity has been started by the assessee. The assessee submitted all the relevant documents including the bylaws, or you can say that the memorandum of activities before the Learned Commissioner of Income Tax Exemptions and seeked registration. After the pursual of the registration and the documents, the application for Section 12A was rejected by saying that the information has not been provided by the assessee according to Rule 17A. Perhaps in this case, the Learned Commissioner of Income Tax Exemptions wanted to say that the documents related to the activities of the assessee has not been submitted. The evidence of the occurrence of the activities has not been submitted. But the point of the assessee was that since I have not started my activities, so it is not possible for me to give the evidence of the activities carried on by me. So basically in this case, the application of the assessee was mechanically rejected under Section 12A. The assessee, in spite of going into the appeal for that rejection, filed second time the application under Section 12A. This time the same set of information was given because nothing new has happened. The assessee has not started its activity yet. So the assessee do not have any other thing to produce before the Learned Commissioner of Income Tax Exemption. But this time, on the basis of the basic documents which have been submitted by the assessee, including the bylaws or memorandum of activities by the assessee, this time the Commissioner of Income Tax Exemption provided the registration under Section 12A to the assessee. The apprehension of the assessee was that this registration should be granted to me with the date on which I made my earlier application. But CIT exemption was not convinced with this, so the assessee was before the Honorable ITAT bench that this registration should be given to the assessee with the old date at which the assessee has applied originally with the Section 12A exemption. Although there is no provision in the Income Tax Act that this registration should be with the back date. But in this particular case, the Lucknow ITAT observed that since there is not a single change in the information which has been provided by the assessee earlier and the second time, so it is unnecessary harassment of the assessee, unnecessary delay on the part of the department in granting the registration to the assessee, because no new facts has been brought in by the assessee on the file of the Learned Commissioner of Income Tax Exemptions, or no new thing has been asked by the department for granting the registration the second time. So the ITAT gave the decision in favor of the assessee that in this particular case, in this particular unique case, the registration to the assessee should be given with the date on which the assessee has originally applied for registration under Section 12A. It is very interesting case because there is no law in the Income Tax Act that these type of relaxation can be given to the assessee once the application is rejected and the second time the application is granted. But it was much deserved relief to the assessee that the ITAT gave the relief to the assessee and granted the registration with earlier date. At the end of this video, once again I am repeating the name of the case. The name of the case is SANT Baba AASUDARAM SEWA Samiti versus Commissioner of Income Tax Exemptions. Thank you, friends.